Hi, and welcome to day 5 of our Labor Act Challenge. Today we are unpacking Section 5 of the Labor Act, which deals with the prohibition of discrimination and sexual harassment in the employment. Now, for purposes of understanding this section, we have divided it into two legs. The first leg is the one that deals with discrimination, and the second discrimination in employment, and the second one is the one that deals with sexual harassment in the workplace. Now, for purposes of discussing leg 1, prohibition of discrimination, we have further divided it into 6 parts. Now, I would like to remind you that when we discuss Section 2, application of the Labor Act, you remember that Section 5 that we are discussing today is the only section in the Labor Act that actually applies to all employers and employees. That having been said, let's start with Part 1 of Leg 1. Part 1 deals with the definitions of the section. So for purposes of this section, AIDS means acquired immune deficiency syndrome, a human disease which is caused by the HIV and which is characterized by the progressive destruction of the body's immune system. Employment decision means or includes access to vocational guidance, training and placement services, access to employment and to particular occupation of jobs which include advertising, recruitment procedures, selection procedures, appointment and the appointment procedures, promotion, demotion and transfer, remuneration and other terms and conditions of employment, access to and provision of benefit facilities and services, security of tenure or discipline, suspension or termination of employment, dismissal arising from collective termination or redundancy. For purposes of this section again, family responsibility means responsibility of an employee to an individual who is a parent, spouse, son, daughter, or dependent of the employee, and who, regardless of age, needs the care and support of that employee. For purposes of this section again, HIV means human immunodeficiency virus, a virus that weakens the body's immune system, ultimately causing AIDS. For purposes of this section, person with disability means an individual who suffers from any persistent physical or mental limitation that restricts that individual's preparation for entry into or participation or advancement in employment or an occupation. Racially disadvantaged persons means individuals who belong to a racial or ethnic group that was or is directly or indirectly disadvantaged in the labor field as a consequence of social, economic, or educational imbalances arising out of racially discriminatory laws or practices before the independence of Namibia. Work of equal values means work that is of the same or compared with any other work is broadly similar in nature, having due regard to the frequency with which any differences in relation to the first mentioned work and such other work occur, and the natural extent of such differences does not justify the determination of conditions of employment which differ from the conditions of employment prevailing in respect of any employee of the opposite sex performing such work. Work that requires skills, abilities, responsibilities, working environments, or other requirements which are of equal value to employees belonging to any sex. Now that was part 1, the definitions. Now part 2 deals with the rule, the prohibition of discrimination. In terms of this section, a person must not discriminate in any employment decision, directly or indirectly, or adopt any requirement or engage in any practice which has the effect of discriminating against any individual on one or more of the following grounds: race, color, or ethnic origin, sex, marital status or family responsibilities, religion, creed, or political opinion, social or economic status, degree of physical or mental disability, AIDS or HIV status, or previous, current, or future pregnancy. Now, that's the rule that and the grounds on which one must never discriminate an employee against or potential employee. Part 3 deals with what discrimination includes. For the purposes of this section, it is discrimination on grounds of sex to differentiate without justification in any employment decision between employees who do work of equal value or between applicants for employment who seek work of equal value. Part 4, what discrimination does not include. For purposes of this section, it is not discrimination to take any affirmative action measure to ensure that a racially disadvantaged person, women, or person with disabilities enjoy employment opportunities at all levels of employment that are at least equal to those enjoyed by other employees of the same employer and are equitably represented in the workforce of an employer. It's not discrimination to select any person for purpose of employment or occupation according to reasonable criteria, including but not limited to the ability, capacity, productivity, and conduct of that person, or in respect of the operational requirement and need of the particular work or occupation in the industry in question. It's not discrimination to distinguish, exclude, or prefer any individual on the basis of an inherent requirement of a job. It's not discrimination to take any measures that has been approved by the Employment Equity Commission in terms of the Affirmative Action Employment Act number 29 of 1998. It's not discrimination in the case of a female employee who is pregnant to temporarily reassign her duties or functions other than her normal duties or functions which are suitable to her pregnant condition, provided that the reassignment does not lead to a reduction in remuneration or any other benefits. Or, in the case of a person with disability, it's not discrimination if that person is, in consequence of the disability, incapable of performing the duty or functions connected to the employment or occupation in question, or is so prohibited by law and given specific or special preference. Part 5 deals with the disputes concerning interpretation or application of this section, in particular subsection 2. In any dispute concerning the interpretation or application of subsection 2, meaning the subsection that deals with discrimination, the complainant must establish the fact that prove the existence of discrimination. If the existence of discrimination is established, the respondent must prove that the discrimination did not take place as alleged, or that the facts provided do not constitute discrimination in terms of this section. This is just to say, if there is a dispute, then it just means that the person complaining must actually just establish the facts or prove the existence of discrimination. And secondly, if there is that existence established, then the respondent must prove that the discrimination did not happen, or at least if it happened, that it does not constitute discrimination in terms of this act, or it is justified in terms of this act. Perhaps it relates to a pregnant woman who can't do certain work as the same person that they are employed in the same position. So part 6 deals with the defenses in dispute alleging discrimination. In a dispute alleging discrimination without justification, it is a complete defense to the allegation if the decision taken by the employer was in compliance with the affirmative action plan, which is approved by the Employment Equity Commission in terms of the Affirmative Action Employment Act 29 of 1998. So if the alleged discrimination is made in terms of an affirmative plan, then it can be a defense, as long as that affirmative action plan is approved by the Employment Equity Commission. It is also a defense if that action that's alleged to be a discrimination was taken in terms of Section 19(1) and 2 of the said act, or the same act, which is the Affirmative Action Employment Act. Now, Section 19 simply says that in filling a position, preferential treatment must be given to a suitable qualified candidate who falls within the following designated categories, which is racially disadvantaged persons, women, and persons with disabilities. And if two or more people fall under such category, then the one that is Namibian will be preferred. And if more than one Namibians fall under such categories, then the one that falls under more categories that are listed then must be preferred. Let's move on to theme 2, which is the prohibition of sexual harassment in employment. So part 1 deals with the definitions relating to sexual harassment. So for purposes of dealing or discussing with sexual harassment in this act, employee includes a prospective employee. So it can be an applicant or someone that's just aspiring to become an employee at that specific workplace. Sexual harassment means any unwarranted conduct of a sexual nature towards an employee which constitutes a barrier to equality in employment, where the victim has made it known to the perpetrator that he or she finds the conduct offensive, or the perpetrator should have reasonably realized that the conduct is regarded as unacceptable, taking into account the respective positions of the parties in the place of employment, the nature of their employment relationships, and the nature of the place of employment. Part 2, rules on sexual harassment. A person must not in any employment decision or in the course of the employee's employment directly or indirectly sexually harass an employee. Where sexual harassment is perpetrated by an employer against an employee and that employee resigns as a result of the sexual harassment, that's the resignation, constitutes constructive dismissal. Now, just to explain, constructive dismissal just means that that person is assumed to have been dismissed or to have been forced out of work and therefore has a claim against this employer. A constructive dismissal contemplated in this subsection may constitute unfair dismissal. For the purposes of Section 33, which entitles the employee to remedies available to an employee who has been unfairly dismissed. So when you leave a job because of sexual harassment, then it means that you will be treated as if you did not make that decision on your own, but you were unfairly dismissed, and therefore has the same remedies that an unfairly dismissed person has against an employer. So ladies and gentlemen, that brings us to the end of section 5. Let us engage, let us discuss, let us learn on either one of the platforms, whether it's on our WhatsApp, Instagram. Let's engage. Thank you.